We have Heather Bruce and Loretta Davis here from Swagger and Bruce Law Firm. Heather will be presenting today, and then Loretta will be here to answer questions. You are all put on mute to help keep down on background noise. If you have any questions or comments, you can use the question and answer box at the bottom of the screen, and we will be keeping an eye on that to answer any questions or respond to you. So again, thank you for joining us today, and I'm gonna hand it over to Heather.
Thank you, Jasmine. Appreciate it. Everyone, thanks for joining us today. I want to give a quick thank you to TVA Credit Union. They've asked me to do this now running on about 9 or 10 years. So I do this twice a year, once in the spring and once in the fall. It's typically an in-person presentation, as you can imagine, and it's interactive and it's educational. And today's going to be a little bit different, and it looks a little bit different. But we are able to, we're going to have a couple poll questions throughout the presentation. I'll announce those questions, and then you'll be able to vote, I think, near the bottom of your screen. So that will help you to have a little bit of input. And then also, there is a Q&A box, again, near the bottom of your screen, where if you have a question that you want to ask during my presentation, go ahead and ask it, type it in. If it's something that can be easily answered by Loretta, who's my paralegal, she'll answer that for you while I'm speaking. If it's something that she feels should be presented and that I should speak about, she will shoot that over to me, and I will address that for the whole crowd as well. So I first want to start off by just kind of going through, you should have all received an email with a few pieces of paperwork. The first is just our agenda for today. It looks like this. It's a straight talk about estate planning, just kind of a PowerPoint pinpoint of what we're going to talk about today. Behind that, or just after that, is a 2-page common questions. So this is just kind of what we've gotten as questions kind of over the years. And so that's a 2-page document. And then the last in your packet is if you wanted to do estate planning updates or start an estate plan with our law firm, there is a packet near the back. And that's informational purposes if you choose to schedule an appointment with me in my office. So I'm going to start off with introduction. So that's an easy enough one. My name is Heather Bruce. I am an estate planning attorney here in Traverse City. I've been practicing in Traverse City for about 16 years now. So born and raised in Benzie County, and went to the University of Michigan for my undergraduate degree, and then on to Thomas Cooley Law School for my law degree. I practice solely in this area, so I do estate planning. We also do trust and probate administration after someone has passed away. We help with deeding, real estate matters, land contracts, things of that nature, and business formation. So again, this is educational. We want it to be somewhat interactive, so go ahead and answer questions as I'm speaking, and I'll do my best to provide answers to those. The first topic that we're going to talk about today is wills and probate. So this leads us to our first poll question, poll number 1. And the question is, I think Jasmine's going to pull that up for us. How many who are attending today have an estate plan? So yes, no, or I don't know. Could you respond to that poll question number 1? How many of you have an estate plan already in place? All right, we have most answered no. So about 90% answered no, 10% answered yes. Okay, so what's interesting about that is if this is a pop quiz, 90% of the class failed. Those of you who said that you do not have an estate plan, you don't have something in place, are incorrect. And the reason for that is because although you may not have an estate plan that you prepared in place, the state of Michigan has an estate plan for you. And those statute books tell us exactly what happens to your estate if you pass away without a will or a trust. So the first takeaway kind of is everyone has an estate plan. It's just, have you participated in the preparation of that plan or not? So for 90% of you that said no, you're in the right place. First of all, we're going to talk about some basics of estate planning, but know that you do have an estate plan in place. It just might not be the one that you would have chosen for yourself if you had done it for yourself. Okay. So our first topic is wills, wills and probate court. We got a second poll question. There's only 4 total, but the second one comes right away here. Poll question number 2, if Jasmine could pull that up. Who thinks that having a will avoids probate court? Answers are I do not, or I have no idea. Who thinks that having a will avoids probate court? We have a couple more seconds there to respond. Oh, interesting. Oh, well, and everyone passed with flying colors then, the second poll question. So the question is, who thinks that having a will avoids probate court? All of you said, well, one of you said, I don't know, which is a really honest answer, which I appreciate. The rest of you said, you do not think that. So, and no one said that they do think that, which is surprising. I usually have about half of my audience members saying that they think that having a will in and of itself will avoid the probate court process. So most of you get a gold star for this question, but the answer is having a will in and of itself does not avoid the probate court process. And here's why. So a will is, as most of you probably know, right from movies or kind of hearing these things or TV, a will is what a lot of people have as an estate plan. It tells us what happens to my estate after I pass away, who is in charge of that process. The will itself might be only a few pages long, so most of my wills are probably documents that are 5 or 6 pages long. And the will itself can be pretty straightforward. It says I'm a resident of, Benzie County. I may be married and have children, and here's where I want my estate to go. Here's who I want to be the personal representative or the person in charge of that process. What's interesting, though, is having that will in and of itself doesn't avoid probate, because to the contrary, having only a will and doing no further estate planning almost guarantees that you will be going through the probate court process. And the reason for that is the will is your written instruction to the probate court about what you would want to have happen to your probate assets. So that begs the question, what is a probate asset, or what do you mean when you say probate? A probate asset is if at the time that you pass away, you owned an asset solely in your own name. You didn't own it jointly with another person. You didn't have designated beneficiaries on that asset. Your trust didn't own that asset. If at the time that I pass away, I owned an asset solely in my name, that is a probate asset. And that asset will likely have to go through the probate court system. And where we look to see what your instructions were about that asset is the words of your will, is what you said in your last will and testament. So having a will might help us have an easier probate process, but it certainly doesn't avoid that process altogether. So a lot of people have probably heard maybe from some friends, family members, neighbors, that you want to avoid probate court if possible. I for the most part, agree with that statement. And you may have heard some horror stories from people who have been through the probate court system, who say things like, people were fighting. The probate process went on and continued for years. It cost a lot of money. Those are pretty true statements. So we've seen that happen for sure for certain clients of ours. For the most part, if we can avoid probate court, that's a good thing. And there's a couple reasons why. So first off, when someone passes away and they do have a probate asset, so they did pass away owning an asset solely in their own name, if someone needs to now take that will for that person and probate it through the probate court process, that is a public process. And the way that that process starts is the personal representative, the person who you appointed in your document to be the personal representative, takes your will, the original will, files it with the probate court in the county where you resided at the time of your death. They file a death certificate for you, and they file some probate pleadings or paperwork. There's some court filing fees that are also charged at that time to open the probate case. And there are several pleadings or probate court forms that also need to be filed. So the way the process works then is anyone who's named in your will to receive something, or, and make a note of this, anyone who is, maybe they're not named in your will, but maybe they are an heir of yours. And so I always kind of use this example of, let's say for the purposes of this entire presentation that I have two sons, which I actually do in real life. But let's say I have two sons. I have son A, who I love dearly, and I have son B, who I, for whatever reason, I don't love dearly. My joke is always, son A, he went to the University of Michigan, he got all A's, he did everything I expected of him, and I love him, and I want him to receive all of my estate when I die. Son B, he went to Michigan State. I never thought that he really accomplished much in life. He didn't live up to his potential, yada, yada. So let's just say, hypothetically, that that's my situation when I pass away. Now, if I have a will, and in that will I say, I'm Heather, and when I pass away, I want everything to go to son A, and I specifically exclude son B. The problem is when my personal representative takes that will to probate court and opens a probate estate for me, there are certain requirements in probate court as to who gets notice of the proceedings. So not only does son A get a copy of my entire will and all of my information, son B, who I've explicitly written out, also gets a full copy of all of that paperwork. And so a couple reasons why people want to avoid probate court is it can be costly. So in addition to the court filing fees, there are several different pleadings that need to be filed with the court at certain deadlines, and you typically need an attorney to do that for you. I printed out, just as an example, these are just probate court pleadings. It might be difficult to see how many there are here, but this is an example. I'm just going to kind of flip through. These are all of the probate court pleadings that need to be filed each time that you open a probate estate in Michigan. Very detail oriented. You need to file these all at the right time. So cost is kind of one of the reasons why we avoid probate court. One of the others, and a big one for some of my clients, is what I was just alluding to, is in the situation where we maybe have some heirs or people in our family that we do not want to receive a full copy of our estate plan. Some people like to avoid probate court for the reason that it is a public forum. The court documents are public in nature. There's an inventory that's filed that tells the court and anyone exactly what you owned at the time that you passed away. And so those are just, sometimes I have clients who say, I don't really need people to know all that information about my estate. I would rather have that be a private process and not have to go through that public court proceeding. And I do see a question here, so I'm just going to take that. Oh, good question. Okay, so the question is, explain what probate administration is. I thought when you die with a will, everything is just done and your property goes to whomever you gave it to in your will. Can you explain that? So sure. The will, like I described, is just kind of our written set of instructions about what happens to your probate assets. Even if you've nominated someone in your will to be your personal representative, that person actually does not have any authority to act on your behalf unless and until the probate court judge actually appoints that person as your personal representative. So the will is your list of wishes or your desires or your list of instructions, but the personal representative who's named in your will actually has to take that will to court and follow through with some steps in probate to actually be appointed for you as your legal representative, as your personal representative. Once that is done, the personal representative has a job to do to administer that probate estate. So like I mentioned, there's an inventory that needs to be filed listing all of the probate assets, the value of those. There's a notice to creditors that has to be published in the local newspaper. your personal representative has to kind of pay any claims against your estate, gather assets, and then, you know, disperse those proceeds. So there's several steps that need to be followed in a probate administration. There are deadlines involved that most people wouldn't know about unless maybe you had an attorney helping you. So for the most part, when we're helping someone with a probate administration, the probate attorney is doing a lot of the work, the attorney and the paralegals, because there are certain forms that have to be filed at certain times that most of my clients wouldn't necessarily know about if they weren't doing this on a daily basis. Okay. Here's another question. Who might I name as a personal representative if I don't have any children? Does someone have to be related to me to be named a personal representative? Great question. So no one has to be related to you to be named a personal representative. There's really no statutory requirements in that regard, other than we want someone who's suitable for that role. And by suitable, we just mean someone who really is that you're trusting to act for you. So someone that you trust to be organized with paperwork, someone to follow through and make sure that the probate paperwork is filed and followed through with. So this could be a trusted family friend. It could be a niece or nephew if you don't have children. We can also help you discuss whether it might make sense for you to have an independent or a neutral personal representative. It can be either a bank, a trust department at a bank, or sometimes that can even be a local company where we have professional fiduciaries who serve in that role. That's a good question. But really, some of this is kind of sitting down and having a conversation with an estate planning attorney who can talk with you about kind of the pros and cons of naming a relative versus someone else for this role. It's really important that you have someone that you trust to do that for you. So will is just our direction to get us into probate court. It does not avoid that probate process. A lot of people want to avoid probate court, and sometimes for good reason. And so we don't have time today, but I can tell you horror stories of what can happen in probate court, or what has happened in files that I've been involved with. Some have taken years and years. Some, there's attorneys maybe on both sides, and there's will contests. There might be tens of thousands of dollars that are spent in attorney's fees simply because their wills are usually easier to object to than a trust, and we're going to get into that next. I've got one more question here. Let's see if it has to do with what we're talking about. Okay, good. I have a will from 1984. Is that still valid, and should I update it? That's a while ago. So I know where I was in 1984. I was about 7 years old. I was watching the Detroit Tigers win the World Series, which seems like a long time ago. So yes, so the short answer is yes. If you have not revoked that will from 1984, even though it's 36 years old, it is still a valid document. Maybe a better question would be, does that will still reflect your wishes after all of these years? So I do often have clients who come to see me and they bring existing documents. Maybe they bring a 36-year-old will or something of that nature, and they say, I prepared this when the kids were minors and I was going on a trip, and I haven't looked at it since then, or I don't even really know what it says. Let's take a look at it and just make sure that it still meets what your current wishes are. I would say like 95% of the time, a document that is that old is no longer, although it might be valid per se, valid, it doesn't really reflect what your current wishes are and what you would want to have happen with your estate. So it's certainly, from 1984, I would say let's certainly review that and just sit down and look at whether, what that document says and whether it's still fitting what you want that to say. There's another question on that I'll answer in a minute. Okay, so the wills, probate, that's kind of just in a nutshell how that happens. I'm sorry, I'm looking over here just to see if there's some more questions. Yes, good. One of the questions is there a way that you can name who would care for minor children in the event that both of you passed away, leaving minor children? So yes, definitely. A will is one place to do that. So if I have clients like me who have minor children, one of the most important pieces of that will document is appointing or nominating who you would want to be the guardian of your children and the conservator for your children. So the guardian is the name for the court-appointed person who would be responsible for the care and custody of your minor children until age 18. And a conservator is the name for the court-appointed person who would be in charge of any funds that are coming to minor children. So yes, you can certainly do that in a will, and I would recommend that. You can also do that in a trust document, which we'll get to in just a minute. But definitely, that's one of the main things that we want to include in a will for those with minor children. I'm going to skip ahead now to our next topic. We're on to revocable living trusts. And I believe that's our, we'll throw the poll question number 3 in there, Jasmine, if you could put that up for us while we talk about trusts. Question number 3, who thinks that you don't need a trust due to the value or size of your estate? And so this could be just a question in general, not necessarily asking you about the size of your estate, but who thinks that you don't need a trust because of the value or size of your estate? You do think that, you don't think that, or I love number 3, what is a trust, which is what I'm about to talk about. So who thinks that you do not need a trust because of the size of your estate? Very good. Okay. I have my 10% who said, what is a trust, which I love. The 2 other answers were split evenly. So about half of you think that you don't need a trust because of the size of your estate, and the other half do. So when we talk about trusts, and people kind of throw that word around and you hear it, 20 years ago, 15, 20 years ago, when people said, I have a trust, or I'm going to prepare a trust, the connotation to that kind of trust was a little bit different than it is now. Years ago, so again, 20-ish years ago, a lot of people had a trust because they wanted to save some of their estate from going to the federal government to pay federal estate taxes. And so for a time, years ago, I would say it was more true that you might not need a trust if you had a relatively small estate. Trusts were reserved for people who really had maybe multiple millions of dollars, and they were wanting to save some federal estate taxes. Because the federal estate tax is something that applies to each of us. For the year that you pass away, the federal government has what's called a federal estate tax exemption level, which applies in the calendar year that each of us will pass away. So years ago, and I just looked at this for someone who has a trust from 1998, for example. In 1998, if a married couple went to see an estate planning attorney to have an estate plan prepared, one of the things that that attorney would have spoken with them about is the fact that the federal estate tax exemption level, meaning the amount that each of us can pass away with in our estate and transfer without having to pay federal estate taxes, that level was fairly low. Back in the late 90s, it was about $625,000. So back in the late 90s, if a married couple had gone to see an estate planning attorney and they sat down with that attorney, and when they added the value of their home and their 401ks and their life insurance and their bank accounts and their brokerage accounts, they were sitting at about $1 million. That attorney likely would have said to them, oh, you definitely need a trust, and you even need a special type of trust. You each need your own trust so that we can avoid paying federal estate tax. Now, right, so I get a lot of people who say, I don't think I need that trust because I don't have a huge estate. Well, first of all, the size of your estate is, to me, it's all relative, right? It's whatever is yours is yours. I don't look at the zeros. That's not the kind, that's not the kind of attorney I am, and I can explain why. When we say trust now, though, we're not looking at tax savings and doing this to maybe maximize any federal estate tax savings. And the reason for that is because that federal exemption level now for federal estate taxes, where it used to be about $600,000, maybe 20-ish years ago, That amount for 2020 now is about $11.5 million per person. Meaning, right, each of us, if I passed away in 2020, I can pass my first $11.5 million to whomever I want to without having to pay any federal estate tax. So most of my clients don't have an $11.5 million estate. So those tax savings, or the reason for doing these trusts, really has gone away. Most of my clients who are like the idea of a trust are doing that for different reasons. So to simply say, yeah, I don't think my estate is of a certain value that necessitates having a trust, that's really a fallacy. We shouldn't really think that way anymore. A better way to think about the types of trust that I prepare mostly now is think of that trust as a will substitute. So rather than having your will be kind of the centerpiece of your estate plan, you're going to actually get kind of, it's another level of estate planning. It's one more level of estate planning. Your trust is now going to be the centerpiece of your estate plan. So the trust is really just a will substitute. And the type of trust that I'm talking about when I'm talking about trusts for the next few minutes here is what's called a revocable living trust. That means revocable. Some people say revocable. That just means it's amendable, right? A living trust means it's a living, breathing document that grows with you. And as long as you are alive and competent, you can make changes to that document. So what's also kind of neat about these revocable living trusts is that spouses, and so I did have a question earlier about same-sex couples. Certainly this planning applies to any spouses in Michigan. A lot of my clients like the idea of a revocable living trust because we can do one joint trust for a married couple, and that really is the centerpiece of your estate plan. A lot of people say, if I have that trust then, which I might like to do that, why do I still need a will, or do I still need a will? And the answer is yes. It's kind of silly, but if you picture, let me show you, I've got some props. This is, it's very big, but this is our trust box, okay? So this is just a box that we've wrapped and it's got an open top on it. Let's envision this as our trust here. And so we're gonna kind of set that in the back. The beauty of your trust is that it's there to kind of be a separate legal entity that's gonna own certain of your assets. So I'll show you how we can do some of that deeding and funding of assets into your trust. But even if you have that joint trust as a married couple, each individual person still needs his or her own will. And it's just a special kind of will called a pour over will, which simply means, although we're trying to get most of our assets into this box at the time that we pass away into our trust, if we miss something or forget something, your will is a pour over will, which simply says, I'm going to take that asset that is a probate asset now, that I maybe forgot to put into my trust, and I'm going to pour it over and put it into my trust. So even if you have a trust, you still do need a will. It's a real simple kind of will called a pour over will. It's usually 3 or 4 pages long, not real long, not real involved, but it pours everything over into your trust. So again, getting back to kind of this idea of a revocable living trust as a will substitute, one of the main reason why my clients, some of them really like the idea of a trust as opposed to kind of just a will for their estate planning, is your trust, if funded properly with your assets, can completely avoid that probate court process that we talked about earlier. So the way that we accomplish that is, and the goal of the trust planning is, I'm Heather and I'm an individual, and my goal with having this trust is that at the time that I pass away, I do not want to own any assets in my own name because I don't want any probate assets. So the trust planning is quite a bit different than having a will prepared. So if you just came to see me and we did a will, and that's fine, you know, we do the will and we're kind of done with it, but that's not avoiding probate court. With trust planning, you know, and then the trust, if you picture this kind of out on the outside of our box are the written instructions about what you want to have happen with whatever assets are in this box. The trust planning process doesn't stop with just the preparation of the trust document. We need to go a step further and actually fund this trust with your assets. And so the way that we do that, and I have some props to show us here. If you've got a TBA credit union checking or savings account in your own name. So right now that account is just owned by Heather, and I'm an individual person. But now I've prepared Heather's trust. I might take this TBA credit union account and change either the titling on the account to name my trust as the owner, or I might name the trust as my trust as the beneficiary on this account when I pass away. The goal though is that these accounts at TBA Credit Union, now they're in my trust. Okay, when I die now, I don't own those in my own name. They're not probate assets. My trust actually owns those assets. We can do something similar with jewelry. So we've got jewelry here, right? Personal property. So any personal property that you own in your own name, we would want to assign all of those assets into your trust so that we could be sure to maybe have a list of those assets and say, you know, grandma's necklace goes to a certain child or a certain niece or nephew or something of that nature. Another thing that we can put into that box is our house, right? So here's my house, and right now I own that just in my own name, but I'm wanting to do a deed where I actually transfer ownership of that property into my trust so that my home is never a probate asset. It never has to go through the probate process when I pass away. So that can only be accomplished, the transfer of ownership of real estate can only be accomplished by actually filing and recording a deed in the Register of Deeds for the county where that property is located. So that deeding is another piece of that trust funding process that we would help you do. Other things, we've got some stock certificates. So if anyone's owning stock certificates or investment accounts in their own name, again, we can either put those assets right into the trust during life by changing the titled owner of that account or the owner on that stock, or we can just name the trust as the beneficiary of those assets at the time that you pass away. Now, so avoiding probate, right, that's great for that trust. Another advantage, frankly, to the trust as opposed to that will is where I discussed in the will conversation about the fact that even if you've written out son B who gets nothing, right, he still gets a full copy of your will, and so now maybe he's going to contest that will in probate court. Unlike the will, there are different statutes that apply to a trust and how we administer a trust. So let's envision that same hypothetical scenario where my trust gives everything to son A and leaves nothing to son B. In this case now, if that's what my trust says, my successor trustee, that's just the name of the person who's filling that fiduciary role, after I've passed away, my successor trustee is going to administer my trust estate. He or she's going to read, hopefully, read that trust document and see, okay, Heather wanted son A to get everything and son B's not to get anything. You know, that's their job. So they're going to gather assets and make sure that that's done. One great thing about a trust, as opposed to that will, though, is that the trust is a private document. And so we're not filing that trust at all with the probate court. There's no filing fees then with the probate court. We're not filing an inventory at all. And son B, in this scenario with a trust situation, son B receives no notice of anything from the trustee. If son B is not a trust beneficiary, he is not entitled to notice of what's going on in that trust administration from the trustee. So a very different situation than kind of that standard probate that we talked about at the beginning of the presentation. A trust administration is done privately. It is accomplished typically by sitting in an office like mine, you know, going to see an attorney and doing that on your own timeline rather than kind of that probate court timeline. So very, very different. We're kind of comparing, you know, apples and oranges here in terms of a probate administration and what is necessary versus a trust administration and what is necessary there. And I have a couple questions here. Let me grab those. All right, so the question pertaining to trust is, do you have to name an administrator of the trust? So yes, where in the will situation that the name of that person was the personal representative, the name of the fiduciary who acts for you over the trust assets is the trustee. So while you are alive and have full legal capacity, you are always the trustee of your own trust. at the time that you pass away, or if you become incapacitated during your lifetime, your successor trustee will step in for you and manage that trust. So maybe that same question that we had earlier is, you know, does a trustee have to be related to you? Does it have to be an individual? No, so those same rules apply. Your successor trustee can be an individual person. So your trustee can be a child who is also a beneficiary of yours. That's okay. A trustee might also, though, be, again, that neutral, independent person that you want to step in because you don't want either of your children maybe to be the trustee. You want to have a bank trust department, a corporate trustee, or you might want to have that independent fiduciary to step in and do that for you. It's, again, up to you. You want to appoint someone who you know is going to be thorough, who's going to read documents, ask for help if they need help. You know, I always say it's someone who can balance a checkbook and get the mail and just takes care of their own business in their own life. That's the kind of person that we would want to appoint to be a successor trustee for us, because we want to make sure that they're following through with everything they need to do. A couple more questions here that pertain. Yes, very good question. So can a trust hold back funds to be paid out at a later time to a child with special needs? Definitely. So this is the flexibility of a trust document is also one of its main advantages. And that is because in a trust situation, I often have clients who come to me and they say, for example, you know, we have a blended family, or I have some children who I want to receive my estate, but I do not want them to receive that all at once. Or, you know, I want to encourage college education and things like that, and I don't want 100% distribution to go to my beneficiaries or my children right away. I really want to hold some of that back in the trust, and I maybe want to have some restrictions as to the distribution of those funds. So yes, definitely, a trust is the way to go if you have a child with special needs. You can actually set up a special needs trust within your revocable living trust that is funded with, you know, that special needs trust can be funded with assets at your passing that could then be held and protected for the benefit of that child. We can also build in some age restrictions. I have many clients who come to me and say, gosh, I have 2 kids and they're adults, but I'm still not comfortable with them receiving 100% of their inheritance all at once. So we often do something like, you know, maybe there's 2 children and we have an equal distribution to the children, but we want a third of the assets going to the child at age 25, a third at age 30, and then the remaining funds at age 35. Something of that nature where we're kind of holding some of those proceeds back. The trust is the perfect vehicle to do that. And again, we're not in probate court, so we're not worried about probate court filing fees and deadlines and timelines. The trust administration is done privately, again, usually with an attorney, but it's done on the trustee's own timeline rather than kind of going through that pretty strict probate process. Yeah, do I help a trustee with their job as trustee? Yeah, so the trust administration process, you know, we're talking about the planning side here, and the differences kind of between a will and a trust. But the administration side is what we help with after someone has passed away. And with a will, and we're going through probate court, that is just a probate administration. If we have everything in our box, right? If we had all of our assets in our trust and we were avoiding probate court, then we would be helping with the trust administration. Again, we're kind of comparing apples and oranges with what's required in each of those. But yes, there are a couple of deadlines that apply to trustees as well. And it's very important that you, if you don't know what you're doing as a trustee, that you hire, you know, an attorney who can help you do that. We also sometimes are helping with property cleanouts, right? We're cleaning personal property out of the house. We're helping find a realtor to sell the trust home, maybe you know, a financial advisor or a CPA or someone to help with some taxes for the trust. So definitely you want to surround yourself with a good team of professional advisors who know this area of law. Yeah, that's a good question too. Who contacts the trustee after I die to let them know that they are the trustee? So first of all, we wouldn't want that trustee to only be learning about that after your death. We don't want that. So what we typically do is Once your documents are prepared, and let's say you've appointed your sister as the trustee, the successor trustee of your trust, we would want your sister to first agree to do that, right? So have a talk with her and make sure she's okay with that, assuming that she is, and now she's been named in the document. What I like to tell clients is, you take all of your original documents and store them in a safe place, and just let your sister know, look, if something happens to me, there's a binder that has all of these documents in it. Here's how you find it. But you let that person know ahead of time that if something happens to you, they need to step in and find that paperwork. You want to organize it all in one spot so that when they go to find it, if there's an accident or an emergency, they're not rummaging kind of through your paperwork. They know exactly where to find that information. What's nice too is our office is somewhat paperless, so anything that's signed here at our office is also scanned in, so there is a backup on the cloud, a computerized backup of all the signatures of anything that you would sign through me. So that's also important too, to have a backup for all those important documents. Okay, there's very good specific questions here. I think maybe what I'll do is it kind of blends into the next topic, one of the questions. So I'm just going to kind of address, assets and funding and how do we do some of this. One of the questions was if there's if just one person in a joint ownership passes away, do we still have to go to probate? So no. A probate asset, again, is just an asset that would be owned solely in your individual name. If you have a joint owner, if it's owned as husband and wife, or you've named a child as a joint owner on an asset, as long as that person survives you, that's not a probate asset, but that asset would pass directly to that other joint owner. So I want to give just maybe a little caution here in doing kind of joint ownership or adding. I see a lot of clients who want to add children to their deeds or add children to their accounts as owners. Typically, there are better ways to plan your estate than making a lifetime gift of that asset and adding your children as joint owners. Again, we're not going to get into the topic in full today, but Medicaid it can be an issue if you are adding children to your home as joint owners. If you are gifting anything away, we certainly don't want people doing that on their own. Really bad things can happen if you try to do your own estate planning by just adding children's names to things or giving things to children. One example might be if you've added, your 3 children's name to the deed of your home, and then one of those children is going through a divorce or gets into a bad car accident and hurt someone. I certainly wouldn't want any of my clients to open up themselves to any potential liability by doing some of this, what I call do-it-yourself estate planning. It really is important to kind of meet with a professional and make sure that you understand all of the pros and cons of each type of situation. So yes, a true joint ownership situation will avoid probate court. Is it the right thing to do for you? Maybe, maybe not. So we want to sit down and talk about whether that joint ownership is the way to go. But yes, that would avoid probate court for that asset. Yeah, very good. So there's a question about ladybird deeds. So someone's either attended another one of my seminars or has been reading good articles, but a good question. So this is kind of on our next topic of, how do we do this funding and how do we avoid probate court? When I was talking about my house and owning that in my own name, I talked about deeding that into my trust. For most of my clients, like 90% of them, one tool that we can use that really helps them is a certain type of deed called a ladybird deed. So it's just a form of a quitclaim deed that is a better way to think of it maybe as a transfer on death deed, whereby I might take this house, and again, it's just in my own name, and I might sign a deed that says, I'm Heather, I'm gonna own this house, I'm gonna keep owning it, I want to be the sole owner, I do not want to add my children as owners, I'm gonna own this property for my whole life. and I can sell it if I want to. I can mortgage it, I can rent it, I can paint it. But when I die, the second that I die, I want this house to now be in my trust. The beauty of that ladybird deed, that transfer on death deed, well, it's great for a couple of reasons. Number one is it avoids probate court for your home. For your any residential real estate, the ladybird deed can be used to avoid probate for that specific asset. In addition to that, in Michigan, a lot of my clients are also looking, we never know, right? We don't know what might happen in the future, but a lot of my clients are also looking to make sure that they can protect any assets that they possibly can in the event that they need to apply for Medicaid for long-term nursing home care. So that ladybird deed is another really good tool for protecting your home, keeping it in your own name, and avoiding probate to pass that home wherever you want that to go. And the reason that Medicaid is an issue here is because in Michigan, your home, as long as it is owned in your own name, not in your trust, but in your own name, your home, the equity value in your home up to about $600,000 is actually exempt for Medicaid purposes, meaning you don't have to sell your home in order to go into the nursing home. You do not need to sell your home to qualify for Medicaid to pay for that long-term nursing home care. So that home is a really important asset that we can protect almost every time by doing that ladybird deeding, that transfer on death deed. So not only can I transfer that to my trust, but let's say I'm an elderly lady and really the only asset that I have left is my house. I have a house and I have 2 children and I don't need a trust. I don't want a trust. All I want to do is make sure that that house goes to my 2 kids when I pass away. We can also do a ladybird deed or that transfer on death deed. We can do it directly to the 2 children so that on the passing, of me, that house goes automatically to my 2 children. And again, that's avoiding probate court. That deed is already recorded during my lifetime. When I sign it, it gets recorded. And when I pass away, my children, all they need to do to show clear chain of title in the title work is record my death certificate. So yes, a ladybird deed is an excellent tool. It can, I use it quite often. So we prepare a lot of those every day. And again, we would want to just sit down and make sure that that fits your situation and that you're understanding the pros and cons of using that type of deeding. It's a great tool, but if someone came to me and they said, yeah, I want to do a ladybird to my 5 kids, and they all can't stand each other and no one talks to each other, that's probably not going to be, I like the ladybird, but I wouldn't want to do it to 5 kids equally, because that could potentially have some different ramifications where those children could be suing each other now in the future. We can avoid that as well by maybe talking about a trust or some other thing. So the ladybird deed is an excellent tool. Most of you could probably use it for your principal residence, and we could talk about whether that's to trust or to to individuals. Okay. Here's a specific question. An attendee is telling us that his father passed away and he's the only child. Doesn't everything just go to me as the only child? The title company said I do not have any authority to sell the house and that I need a probate. What does that mean? So again, I would have to look at the documents, right? So I'd always want to review the deeding and things like that. But it certainly sounds like from the question that when Dad died, that he owned his home in his own name, and he maybe didn't have a ladybird deed and he didn't have some deeding done, so that when Dad passed away, his house is now a probate asset. And even though you're the only child and you may receive everything eventually in the end, we would still have to go through that probate process to get authority for you to transfer that home. And so then the question would just be, did Dad have a will? Even if Dad didn't have a will, you can still open a probate. But yeah, unfortunately, it sounds like that's a probate situation where you would have to open a probate for Dad. Yeah, good question. I also own a home in Arizona. Would that be in a will or a trust? So another great thing about our Michigan will, right? So if you're a resident of Michigan, you're going to want a Michigan trust. Let's say there's a joint, this is our joint revocable living trust in Michigan, and it says everything we want it to say, and we put our Michigan house in here. But we also have a winter home in Arizona. Great thing about this Michigan trust is we can have an Arizona deed prepared. I can't do that because I'm not licensed in Arizona, but I know some good attorneys out there who have helped us. So an Arizona attorney can prepare a deed to transfer your Arizona property into the same Michigan trust. As you can imagine, right, that avoids probate not only in Michigan, your state of residence, but it also could potentially avoid a probate in another state, in Arizona. Most people wouldn't believe, but you can have more than one probate that has to be opened for you. We run into this all the time. We have a few of these open right now. They're called ancillary probate proceedings. When someone passes away, a resident of one state with assets in that state, and real estate owned in another state. So technically you could even have someone that has, or two probate estates, which, as you can imagine, just means kind of double the expense, double the time involved, that type of thing. So definitely, if you're someone who owns real estate in a state other than Michigan, a trust should be kind of high on your list in terms of priorities. Okay. All right, and I know I want to be careful of our time here, and so I'm answering questions as they pop up, but we're also scheduled for kind of a Q&A in a few minutes. So if you have a specific question, just stay on and I'm happy to answer that. I want to, for the last 5 or 10 minutes or so, hit on our last agenda item. And this is, we're talking about incapacity. So, we've been talking a lot about wills and trusts and deeds and things that happen when someone passes away. But these incapacity documents can be just as important, if not more so, for people. So when I'm talking incapacity documents, we're talking power of attorney documents where someone is alive still, but maybe doctors, 2 doctors have examined that person and they have told us that that person no longer has the capability to manage his or her own affairs. They need someone to step in for them. So there's two different documents in Michigan that each of us need. So each of us, anyone 18 and over, needs at least a will, kind of reviewing here, at least a will, maybe more, but at least just kind of a simple will. And then a durable power of attorney, which is a document that says, if I'm declared legally incapacitated, then I want, my husband to serve as my agent, as my power of attorney, and maybe my sister or someone to serve as an alternate. So the durable power of attorney is that second document. And then the third is the patient advocate form, or the healthcare power of attorney. That is just like it sounds. That is the advance directive in Michigan for medical decision making. That document allows you to appoint a patient advocate, an alternate to that person. So I always like to have one choice and then an alternate. And then it also gives some specific instruction about end-of-life care in certain circumstances. So there's a provision that talks about whether you would want your life prolonged by providing life support procedures if you are in a coma and things of that nature. So those 3 documents, everyone needs just those basic documents: a will, a durable power of attorney, and a healthcare power of attorney. That leads us to our final question, the poll question. If Jasmine wants to pull that up. Who thinks that if your spouse became legally incapacitated, you, as the spouse, automatically becomes their legal guardian? So I do think that, I do not think that, or I don't know. Who thinks that if your spouse became legally incapacitated, you would automatically become their legal guardian? Ooh, okay, so about half, all right? So half of you are correct in that just because you're married to someone in Michigan, just because you are a spouse to someone, does not mean that you have legal authority to act for that person if he or she becomes legally incapacitated. We've had several cases in our office where clients come to see me and they're typically, not always, but typically elderly. Someone maybe has some advanced dementia or some other issues. And, you know, they're a married couple and they've been married for years and years. And the spouse who still has legal capacity kind of looks at me and questions why I'm telling them this, but it's true. Just because you're married to someone does not mean that you have given them the ability to act for you if you become legally incapacitated. The only way you can do that is by signing ahead of time, ahead of your incapacity, those power of attorney documents that are then effective upon your disability. If you don't do that, so if you don't have those documents in place and you become legally incapacitated, then the only way that someone would have legal authority to act on your behalf is to petition the probate court to be appointed your guardian or your conservator. And again, here we're back in probate court again, and we're having to file those court fees, and there's reporting requirements to the probate court. If we can avoid that again, so if we can avoid probate court not only on your death, but at your incapacity, we're saving the time and expense that can be created when we're ending up in probate court to be appointed as an agent for someone because they are legally incapacitated. So pretty straightforward forms. Those are also two that everyone needs. Anyone 18 and older in Michigan needs both of those power of attorney documents as well. Good question. So the question is, my husband has dementia. Can I get a power of attorney for him now? No, right? So no. In order to appoint an agent under a durable power of attorney, the person who signs that document needs to have legal capacity. And my job as an attorney is to, you know, I would never have someone sign something that I didn't think, you know, if I didn't think that they understood what they were signing, or if they lacked legal capacity to be signing that document. So if someone has dementia and the doctors have said, you know, that they need a power of attorney, by that point it's too late. And so these are these planning documents, these powers of attorney it's very important to have those prepared while you are competent. And some days, right, most of us might question our capacity, but joking aside, if you've got your wits about you now's a really good time to have those documents in place. And then no one would ever need to go to probate court for you to be able to act on your behalf. You would already have that plan in place. And it can just be activated by doctors telling us that you need someone to act for you, okay? So again, I'm trying to be mindful of our time because it's a beautiful day out there and I'm sure people have things that they'd like to be doing outside. If I could leave maybe just with, you know, those documents that everyone should have, the will, powers of attorney, probably a ladybird deed as well if you own real estate. And then just kind of getting organized in terms of your assets, getting those organized, getting your estate planning documents organized, so that if you're asking someone to act for you, that person can step in and really just pick up for you without having to kind of scramble and find all of your documents. That also is a really important thing. We've seen both sides, both ends of that spectrum, where people are super organized and it's very easy for their family to step in and help take care of them. And then other cases where people come to us with banker's boxes full of loose papers and lots of time spent trying to figure out what's still valid and what's active. You don't want to leave, I think most of you probably don't want to leave your family with that mess of paperwork, right? We want to make things efficient and easy for them to step in. If we're going to ask them to act for us, we want to make it easy for them to do that. So I'm going to open it up now to any questions. How much power does the power of attorney give the person you appoint? Well, that's a good question. So typically we want that power of attorney to be pretty all-encompassing. If we're going to tell someone that we want them to act for us because we can't act for ourselves anymore, we don't want to limit that power of attorney too much. So typically that person is able to do anything from pay your bills, sign a tax return. Now we even include some language about speaking with your IRA holder to make sure that your portfolio is balanced correctly, depending on your age and your financial need. Now too, there's some newer language that allows your agent to do some government planning for you. This can be very important. So we've had to use these power of attorney documents in our office when doing some Medicaid planning with the state of Michigan for certain clients who they have dementia and they're maybe headed to the nursing home, but they need some Medicaid planning done and they can't do it for themselves. So we definitely want to see a well-written, pretty current power of attorney document in place that allows that agent to really step in and do all of the planning necessary to get that person the benefits that they are entitled to. You know, some people have 20-year-old powers of attorney. I wonder if my person with the 1984 will has a power of attorney also from 1984. Powers of attorney you want definitely a little more updated. So if it's something that's beyond 10 or 12 years, if you've got power of attorney documents that are older than that, you're going to want to update those simply because the statutes have changed in Michigan since then. And we really want to make sure that we've got those comprehensive provisions in your document that allow your agent to really step in and take care of all of these issues for you. Another good question, how often should I update my estate planning documents? There's no rule of thumb, you know, there's no hard and fast, you know, every year or anything like that. For the most part, I would say every few years, maybe you should look over those documents, and it never hurts to call and you know, tell your estate planning attorney that you just want to review things and make sure everything's in order. In this area of law, there are not usually huge changes in the law that would necessitate you to make changes in your documents. Usually when I'm making changes or amendments for clients, it's because the clients have called me or called my office and said, you know, so-and-so passed away, or I have a new grandchild, or I sold that home. It might be a change in your own life, kind of a big life change that would really cause you to think that maybe you need to look over your estate plan and make sure that it's up to date. So it really is kind of dependent on you and what your life circumstances are. But there is no rule. I would say maybe every 3 or 4 years, just kind of pull it out and make sure it looks good. Or most attorneys too will look that over for you. You know, if it's a review of an hour or so, they're not going to charge you for that initial consultation anyway, or they shouldn't. I don't. But you know, if it's a stack of, sometimes I get binders to review that are this thick that take me several hours, and I would let you know that if that was something that I would charge for. But it's good to have every few years to just have a look at those and make sure that they're still current. Good question. And are we seeing clients in person, or can we do virtual meetings? So yes, to both. Obviously, we've had to kind of change our protocol a little bit. We are trying to limit in-person traffic here in our office, just for, you know, out of an abundance of caution for everyone who works here. So although we still do in-person meetings, we are typically doing these type of Zoom meetings or telephone meetings for an initial consultation. That process is fairly streamlined. It's taken us 16 years, but we kind of got it down to a science. There is in the packet of materials that should have been emailed to you, and if they weren't, shoot us your email and I'm happy to email it to you. There is an estate planning worksheet that kind of looks like this, several pages. Our process is pretty streamlined in that by the time I meet with you on a Zoom meeting or a telephone meeting to discuss what you might need for your estate planning, you would have already filled out this worksheet and gotten it back to me, so that we are kind of looking over that same paperwork together. It's very helpful to do that way. And then that way that first conversation is not spent with me taking down all of this information. I've already got it in front of me, and we can really talk about you know, what your needs are and what the family dynamics are and things of that nature. I would say, you know, and some people think that estate planning is, you know, cookie cutter and that everyone gets the same documents. You know, and to some extent, some of the documents are boilerplate because they have to be, right? There are statutes that have to be included in these documents, but there really is no one size fits all in terms of estate planning. You really need someone to sit down and talk with you about not only the family dynamic, what you want to have happen, what types of assets you have, and then who do you want to be in charge of that process. It's a lot of my clients, they say, come to me and say, I procrastinated. I didn't want to talk about this. I didn't want to do it because I don't want to think about it. But then by the time the process is over and they're done, they say, gosh, it really wasn't as bad as I thought it would be. Or, you know, I have a peace of mind now that things are taken care of and that I don't have to worry about people fighting or, you know, something dragging through probate. It really brings a peace of mind to a lot of my clients when they're done with the process. We try to make it as easy for you as we can, try to keep you organized and keep you on track. And so I have get a lot of thank you notes and even some homemade pies once in a while, which we all like around here. But it really is something that once you're done with it, it's not as big of a deal as maybe it seemed at the outset. And you can just kind of take that off your list and not worry about it anymore. Can you review a current plan and give advice in terms of updates? Definitely. A lot of what I do is reviewing existing documents. Again, I would look over the packet of information, the worksheet that I send to you. We always I want current information from you, and then I will review the existing documents in preparation for the initial meeting. So we can always discuss if there's something that pops out at me that is a red flag, or that I can at least summarize those documents so that you can let me know if those are still reflective of what your current wishes are. But definitely, yep, I review anything that you provide me.
Heather, I dropped
Yes.
a call on sending the packet, so
Oh, okay.
I'll send it to all the registrants right after.
Perfect. Okay. That Jasmine's and I apologize if you didn't receive an email. It's fairly straightforward. It's the agenda for today's talk, 2 pages of common questions that we get, and then that estate planning worksheet. That is also, we have a downloadable version, Jasmine, of that worksheet on our website. And some people find that nice to just fill that out online as well. That's also available. So our website is, and it's on the materials when you get them, but it's www.swogger, which is SWOGGER, and AND, it has to be spelled out, Bruce, BRUCE.com. So you could go online if you wanted to download and fill out that worksheet. It's the same exact worksheet that we're talking about, which would be, again, www.swoggerandbruce.com. If not, I think Jasmine will send that out to you so that everyone can review that. I think I maybe got one more question. Oh, okay. Yep, sure. All right. Well, again, I thank everyone for attending. I know it's a little bit difficult to do this virtually, but the fact that you're here shows that you're serious about doing something. And so, you know, just getting organized is probably the hardest step, but my job is to make it easy and painless. And I'm happy to answer any questions as well. I think in my, in those materials, if you click on our website, you can also email me questions directly, email Loretta Davis, who's my paralegal, questions directly, or call the office. I'm happy to take questions and do my best to answer those for you. So thanks again. Thank you, Jasmine. Thank you, TBA, and thanks everyone for attending. Bye-bye.